As Barristor Garn from Siam Center Law Group, I want to bring everyone into a topic that is far closer to our lives than most people realize, and one that often becomes a major issue whenever a relationship must rely on the law: the difference between marital property and personal property. Many couples spend years together without ever understanding which assets legally belong to whom. Some assume that if they paid for something themselves, it must belong solely to them, which is not always true. Others believe that personal items such as watches, bags, and jewelry automatically belong to them alone, also not always the case. So I want to begin the discussion by laying the proper foundation. Understanding property rights in marriage is not about preparing for divorce, as many misunderstand. It is about establishing financial order, clarity, and long-term security within the family. This knowledge affects everything from buying a home, making investments, accepting inheritance, managing insurance, or preventing future conflict. Without proper understanding from the beginning, unexpected events such as the death of a spouse, bankruptcy, or disputes with in-laws can lead to serious legal complications. That's why I emphasize that these concepts are not distant or theoretical. They are essential knowledge for anyone building a family because they directly shape our rights, fairness, and long-term stability. Moving into the main content, let me clarify in the most straightforward way. Personal property includes assets a person owned before marriage, assets received as inheritance, or gifts that explicitly name one spouse as the sole recipient. It also includes reasonable personal belongings appropriate to one's status, but this does not mean that all personal use items automatically become personal property. For example, luxury watches or jewelry worth hundreds of thousands or millions of baht are considered high-value assets and therefore are legally presumed to be marital property, even if only one spouse uses them. Meanwhile, marital property includes all assets acquired after marriage, salary, bonuses, business income, investment gains, or anything purchased after the marriage date. Even if one spouse earns all the income, the law considers those assets jointly owned. There are also situations many people misunderstand, such as buying a car before marriage but continuing to make installment payments afterwards. Even though the purchase began before marriage, the installments paid after marriage come from marital funds, meaning the car may become marital property entirely or partially, depending on the proportion of payments made. Another common misconception involves couples who have separated, lived apart for years, or when one spouse becomes a monk or works abroad. Unless a legal divorce is finalized, marital property rights remain intact. Nothing expires simply because the couple has been apart. Ultimately, the law evaluates two main factors: when was the asset acquired, and whose funds were used. If the asset was acquired during the marriage period, it is generally presumed to belong to both spouses. I encourage every couple to understand these principles clearly as they form the foundation for responsible financial planning, fair asset management, and long-term protection, both for your partner and for yourself. Thank you for watching. If this content was helpful, please like, share, and subscribe to our channel so you won't miss our upcoming legal content. For any legal questions, or if you'd like us to cover a specific topic, feel free to leave a comment or contact us anytime.